At 6:12 a.m., 20 charter buses rolled down a county road toward my private ranch, each one packed with wedding guests who believed they had exclusive access to a luxury venue. The problem? I had never agreed to host them, my land wasn't in an HOA, and the woman who sent them was about to learn the most expensive lesson of her life. My name is Daniel Carter. I'm a veteran, a civil engineer by training, and the owner of a 120-acre property just outside Cedar Bluff, Texas. A place where the land still decides who you are before your resume does. I bought the ranch for peace. No HOA. No committees. No color charts for fences or threats about mailbox fonts. Just mesquite trees, limestone hills, a private road, and a steel gate with my name welded into it. The neighboring development, however, was a different story. Cedar Ridge Estates popped up 5 years after I bought my land. 400 cookie-cutter homes, manicured lawns, and an HOA that believed order was the same thing as ownership. They had a board, subcommittees, a compliance team, and a woman named Marlene Whitaker. Everyone called her the Karen, though never to her face. Marlene was the HOA president, self-appointed queen of compliance, and a firm believer that if something existed near Cedar Ridge, it belonged to Cedar Ridge. My ranch bordered the development on one side, separated by a tree line and a county-maintained access road that ended at my gate. From day one, Marlene made it clear she didn't like that gate. It ruins the aesthetic, she told me during our first, and last, civil conversation. And it's confusing for residents who want to enjoy the natural walking paths. I smiled politely. This isn't a walking path. It's my driveway. She blinked like the concept offended her. The notices started subtly. Letters taped to my gate claiming violations of HOA rules. Emails forwarded by residents who assumed I lived under their authority. One notice demanded I remove my livestock fencing because it was unsafe for pedestrians. Another accused me of running an unlicensed event venue because I occasionally hosted family barbecues. I ignored them all. Then Marlene escalated. One afternoon, I came home to find survey flags planted along my fence line. Bright pink markers staked into my soil, each one screaming trespass. A clipboard hung from my gate with a laminated map labeled Cedar Ridge Community Event Access Route. I called the county. They came out the next morning. The surveyor didn't even finish his coffee before he started laughing. Your land's clean, he said. No easements. No shared access. No HOA authority. I asked him to put it in writing. He did. That letter would become Exhibit A. When direct control failed, Marlene tried social pressure. Posts appeared on community boards accusing me of being antisocial, hostile to families, and a danger to children. Someone claimed my gate was electrified. Another said I'd threatened residents with a firearm. None of it was true, but lies move faster than truth in a neighborhood designed like a rumor mill. I stayed quiet. Veterans learn early, don't react until you know the terrain. Then came the flyers. Glossy, full-color pamphlets advertising the Cedar Ridge Spring Gala and Wedding Showcase. Photos of my ranch, taken from drones illegally, I later learned, splashed across the pages. My barn labeled as a rustic reception hall. My meadow described as ceremony ready. The date was circled in gold. I hadn't been asked. I hadn't agreed. And 20 buses had been booked. The morning of the event dawned clear and warm. Texas spring at its best. I was drinking coffee on my porch when the first bus appeared at the far end of the road. Then another. Then another. By the time the 10th rolled in, I was on my feet. I walked down to the gate and closed it, locked it, and waited. 20 buses eventually lined the road like a misplaced parade. Drivers stepped out, radios crackling. Guests peered through tinted windows at a gate that refused to open. Phones came out. Voices rose. Then Marlene arrived. She marched up to the gate in heels too sharp for gravel and a blazer that screamed authority. Her smile froze when she saw me standing on the other side. You need to open this immediately, she snapped. We're on a schedule. I held up the county letter. This is private property, I said calmly. You're trespassing. She laughed. That laugh would cost her everything. The sheriff arrived 40 minutes later. By then the guests were restless. Makeup melting. Kids crying. Caterers arguing with drivers. A bride in tears because her dream venue was locked behind steel. Marlene tried to spin it. She claimed implied access. Community rights. Verbal agreements that never existed. The sheriff didn't buy it. He asked me one question. Did you give permission? No, sir. He turned to Marlene. Ma'am, you need to clear this road. Her face went pale. I didn't gloat. I documented. Photos, videos, witness statements from bus drivers and vendors who confirmed Marlene had signed contracts listing my address without authorization. Then I handed everything to my attorney. Cease and desist letters went out that afternoon. Lawsuits followed. Fraud, trespass, defamation. The HOA's insurance refused coverage. The board panicked. Marlene resigned within a week. Settlements were reached. Apologies issued. Public statements retracted. The flyers disappeared. The drones stopped flying. Cedar Ridge installed new bylaws limiting HOA authority beyond subdivision lines. And my gate stayed closed. Months later, I hosted my own event. Friends, family, no buses. We ate under the stars and laughed about the day 20 buses learned what private property really means. Marlene moved away. The Karen lost her kingdom. And my ranch stayed mine. What most people didn't see that day, the part hidden behind the buses and the shouting, was how calculated Marlene's move had been. When my attorney subpoenaed the HOA's internal emails, the truth came out in black and white. Marlene hadn't just assumed access to my land. She had sold it. Weeks before the event, she'd signed contracts with 2 charter companies, a catering firm, a wedding planner, and a rental company for tents, stages, and generators. Every document listed my ranch address as the venue. Every signature was hers. Every contract contained a clause stating the signer had legal authority to grant access. She never asked me because she never planned to. In her mind, proximity equaled control. And control was something she believed she owned by default. The emergency HOA meeting was standing room only. 400 homeowners packed into the Cedar Ridge clubhouse, many of them still furious about the embarrassment. Their guests had been stranded on a county road. Their reputations bruised. Their wallets suddenly very nervous. Marlene stood at the podium, insisting she'd acted in the community's best interest. That defense collapsed fast. One homeowner stood up and asked the question everyone was thinking. Did you personally verify you had the right to use that land? Marlene hesitated. That pause was louder than any confession. By the end of the meeting, 3 board members resigned on the spot. The HOA's attorney advised them, on record, that Marlene's actions exposed every homeowner to potential liability. That's when fear replaced loyalty. My lawsuit wasn't about money. It was about precedent. We filed in county court, knowing full well the case would draw attention. And it did. Local news picked it up first, then regional outlets. Headlines used phrases like HOA overreach and private property abused. Marlene's name was no longer whispered. It was printed. Depositions were brutal. Under oath, she admitted she believed HOA authority extended wherever community impact existed. When asked to define the legal basis for that belief, she couldn't. The judge's eyebrow said everything. The HOA's insurance carrier denied coverage within days. Intentional misconduct wasn't protected. Faced with personal liability, Marlene folded. The settlement included a 6-figure payment for trespass, defamation, and misuse of likeness. A written public apology published on the HOA website and mailed to residents. A permanent injunction prohibiting Cedar Ridge HOA from referencing my property in any materials. Full reimbursement of my legal fees. Marlene also signed a resignation letter that barred her from serving on any HOA board in the county. She left Cedar Bluff 2 months later. Something changed in Cedar Ridge after that. Residents started reading bylaws instead of trusting titles. Committees shrank. Authority was questioned. Power redistributed. A few neighbors even came by my gate, not to argue but to apologize. I didn't realize how far she'd gone, one man said. Most people don't until the gate closes. People asked me later if I felt bad. About the bride. The guest. The inconvenience. I told them the truth. Opening that gate, even for a minute, would have validated a lie. It would have told the world that pressure beats property rights. Sometimes the kindest thing you can do is refuse. Those buses eventually turned around. They drove back past my fence, past the sign that clearly read private property, no trespassing, past the idea that rules only apply when convenient. And in doing so they carried the story with them. A story about boundaries, about entitlement, and about what happens when someone finally says no. The story didn't die after the settlement. It multiplied. Local news turned into state news. State news turned into cable segments about HOA abuse of power. Legal commentators broke down the case on YouTube. TikTok clips of the locked gate hit millions of views, stitched with reactions ranging from applause to disbelief. The phrase 20 buses became shorthand. Every HOA board in the county suddenly wanted a legal seminar. One detail the HOA hadn't planned for: collateral damage has rights too. The bride whose wedding never happened filed her own lawsuit, against the HOA and Marlene personally. Emotional distress. Fraud. Misrepresentation. Her attorney used my case as a foundation. Depositions stacked. Damages climbed. By the time it ended, the HOA paid more in settlements than it had collected in dues over 3 years. The county ordered a financial audit. What they found wasn't criminal, but it was ugly. Selective enforcement. Unauthorized expenditures. Board decisions made without votes. Vendor kickbacks disguised as consulting fees. Marlene's fingerprints were everywhere. The HOA survived. Barely. I never wanted to be a symbol. I bought the ranch because after deployment I needed quiet. Space. A place where fences meant safety, not exclusion. My father used to say, "Land doesn't argue back." That gate wasn't about anger. It was about peace. Cedar Ridge elected a new board 6 months later. Their first action? A bylaw amendment stating, in plain language, that the HOA had no authority whatsoever beyond subdivision boundaries. They mailed copies to every homeowner. And to me. Someone spray-painted "the gate" on a sign down the road. The county made them remove it. But the name stuck. Drivers slowed when they passed. People took photos. A podcast host asked if he could record an episode there. I said no. Some things don't need narration. Months after she left town, I received one final message. No apology. Just a sentence. "You didn't have to humiliate me." I never replied. Power isn't loud. It doesn't send emails in all caps or print flyers with stolen photos. Power is quiet certainty. It's knowing when to stand still. Read the bylaws. Understand easements. And never assume silence is consent. Because sometimes the gate stays closed. The morning 20 buses stopped at my gate, and HOA learned the hard edge of American law. Authority ends where ownership begins. And when you mistake entitlement for permission, you don't just lose access, you lose everything.